In the late 1700s, the United States still had to decide what kind of country it was. Some states began moving away from slavery. Others depended on it. The new federal government needed a constitution that kept those states together, so lawmakers built protections for slaveholders into the nation's highest law. It became a bargain. Unity came first, even when it meant writing human bondage into the rules. One protection mattered more than people realized at the time. The Constitution said that a person held to service who escaped into another state did not become free just by crossing a border. That meant state lines did not end slavery's reach. A slaveholder's claim followed the person. It was a national promise to return runaways. The idea of pursuit was no longer local practice. It was federal principle. That single promise created a new problem the country could not ignore for long. How did anyone actually enforce it? If an enslaved person reached a state that rejected slavery, who decided what happened next? And whose authority controlled the outcome? State officials or the federal government? The Constitution set the direction without giving the method. But it planted the seed of a future system built to chase, capture, and transport people across state lines. In 1793, Congress turned a compromise into a working machine. It passed the first Fugitive Slave Act, a federal law that laid out how an enslaver could chase a person who escaped. The key change sounded simple, but carried weight. The hunt no longer stopped at a state line. A person could run into a so-called free state and still be treated as property under federal rules. The law created a process to seize and return the accused. Enslavers, or agents they hired, could travel north, grab someone they claimed as a fugitive, and bring that person before a local judge or magistrate. With a written claim and minimal proof, they could get a certificate ordering removal back to slavery. It was not a trial, it was paperwork that decided a life. That federal certificate did more than approve one capture. It signaled to officials in free states that they had to recognize the claim, even if their own state wanted distance from slavery. It also told slave catchers that the national government stood behind them. The result was immediate and lasting. Escape became riskier, and the North became reachable territory for pursuit backed by law. Over the years after 1793, the law stopped being a theory and became a routine tool. People traveled into free states with papers, warrants, and confidence that the system leaned their way. The problem was how little the system demanded in return. Identity checks stayed thin, records stayed scattered, and a person's freedom could hinge on a stranger's claim. That weakness invited a new kind of predator. Kidnappers learned the simplest move: point to a free black man or woman, say the word runaway, and let officials do the rest. Some worked alone. Others formed small crews that watched docks, roads, and border towns for easy targets. A forged affidavit or a bribed witness often sufficed. Once seized, people were pushed south fast before neighbors could gather proof or money. Speed became the weapon. The consequences spread beyond the victims. Free black families lived with a constant risk that legality meant nothing if someone wanted a reward. Travel grew dangerous. Work that required moving between towns carried a new threat. Even long-settled communities faced sudden disappearances that left little trace. The 1793 process, meant to recover fugitives, steadily created a second market, taking the innocent and calling it law. Northern lawmakers did not just complain, they wrote new rules. These personal liberty laws tried to slow down sudden seizures by forcing basic steps before anyone got removed. Some states required a hearing in front of a judge. Some demanded real paperwork, not just an accusation. The goal sounded simple: If someone claimed a person was a runaway, the state's courts had to check the claim first. Other laws targeted the tools that made captures easy. States limited when local jails could hold an accused fugitive, because jail time often became a holding pen until a slave catcher could act. Some barred state officials from helping with arrests. Others punished kidnapping more directly, treating false claims as a crime. Each step pushed in the same direction. Northern states tried to build a shield around free black residents and alleged fugitives alike. But that shield created a direct collision. Federal law still promised enslavers a way to reclaim people across state lines, and slave catchers insisted those promises stayed valid everywhere. Northern protections slowed arrests, added delays, and sometimes blocked cooperation entirely. The same moment could carry two competing commands, one from Washington, one from a state house, and with every blocked capture, the pressure for a national crackdown only grew stronger. In 1842, the fight over fugitive slave enforcement reached the Supreme Court in a case called Prigg versus Pennsylvania. At the center stood a simple question with explosive stakes. Who controlled the capture process, the states or the federal government? The court answered with a hard line. Federal law ruled. State protections that blocked the 1793 system could not stand in the way. But the decision carried a second message that changed the battlefield. States did not have to help. They could refuse to use their jails. They could refuse to order local officers to assist. They could step back and let federal authority act alone. That sounded like a compromise. In practice, it created a new problem. Slave catchers lost the routine cooperation that made seizures fast and quiet. So the pressure shifted to Washington. If states could legally stand aside, then slaveholders and their agents demanded a stronger national tool that did not depend on local help. They wanted more federal muscle, fewer obstacles, and faster decisions. Prigg did not settle the conflict. It sharpened it. It turned a state-by-state struggle into a drive for a harsher, uniform law across the country. In 1850, Congress passed a new Fugitive Slave Act as part of the Compromise of 1850. Lawmakers claimed it calmed a growing national crisis. Instead, it tightened the net. The law no longer treated slave catching as a mostly local scramble. It turned it into a federal project. Washington built a clearer chain of authority meant to work the same way in every state, including places that hated slavery. The centerpiece was a new set of federal officials called commissioners. They operated outside normal state courts and handled these cases quickly. Their job was simple: decide whether a person accused of running away got sent back. Slaveholders and their agents no longer needed cooperation from reluctant local judges. They had a dedicated federal door to knock on, with paperwork, warrants, and the weight of national law behind them. Then the law added muscle. Federal power reached deeper into northern communities, pulling ordinary systems into the hunt. Officials faced pressure to help, and people who refused risked punishment. The process moved fast, and speed became the point. The message landed hard. Freedom in a free state no longer meant safety from pursuit. The federal government acted as the enforcer, and the North became part of the machinery. Under the 1850 Fugitive Slave Act, the process looked official, but the protections people expected from a courtroom fell away. An accused person faced a fast hearing before a federal commissioner, not a full trial, and the most basic defense often disappeared at the start. The law barred the accused from testifying. It meant a person could not even tell their own story under oath. The bar on testimony mattered because the law also accepted thin evidence. A claimant did not need to bring the person's supposed owner or witnesses from the past. Papers and sworn statements carried huge weight even when nobody could truly check them. In that setup, identity became guesswork. A stranger's claim could outrun a lifetime of proof, and the hearing ended quickly. Then the system added a final distortion. Commissioners received higher fees when they ruled in favor of the claimant than when they ruled for the accused. That money did not prove corruption by itself, but it bent the process in one direction. When speed, weak standards, and silence for the accused combined, wrongful captures became easier. The law did not just chase fugitives, it produced new victims. In the early 1850s, enforcement did not just increase, it spread. Federal commissioners issued warrants, marshals formed posses, and slave catchers moved faster because the law backed them everywhere. Northern black communities saw what that meant in practice. One accusation could become a forced trip south. So resistance also changed. It stopped being only private escape. It became organized, local, and ready. Vigilance committees formed in city after city, raising money, watching jails and docks, warning targeted families, and hiring lawyers when they could. Alongside them, the Underground Railroad tightened its routes, moving people in small groups, switching hiding places, and pushing farther toward Canada. Every successful flight embarrassed the law, and each attempt at rescue taught communities what worked and what brought the most danger. Sometimes resistance turned public. Crowds surrounded courthouses, broke into holding rooms, and pulled captives back into the streets, forcing authorities to choose between retreat and bloodshed. The federal response hardened. Marshals used more force. Troops appeared in northern cities, and arrests widened to include rescuers and helpers. The hunt became a test of power, and violence followed that test wherever it went. By the late 1850s, the Fugitive Slave Act stopped being just a law on paper and became a trigger for national crisis. Every capture attempt tested the country's limits: federal power against local resistance, slaveholders' demands against northern outrage. Courtrooms, streets, and state houses turned into battlegrounds. Each case forced a blunt question. If the government could deny basic rights to seize one person, what else could it do? Then the Civil War began, and the entire purpose of slave catching collided with wartime reality. Union armies moved through slave states, and enslaved people fled to Union lines in huge numbers. Commanders and Congress began treating these escapes as a military issue, not just a private claim. New policies blocked returns and weakened enforcement. The federal government that once hunted fugitives now faced a different priority: winning the war. As the war continued, emancipation changed the ground under the law. The Emancipation Proclamation tied freedom to Union victory, and the end of slavery moved from debate to policy. When the 13th Amendment abolished slavery, it removed the legal core the Fugitive Slave Act relied on. A system built to force people back into bondage had nothing left to enforce. The nation's constitution itself rewrote the rules. The Fugitive Slave Act disappeared, and the country rewrote its constitution so no person could be treated as property again. But the machinery it built did not vanish in people's minds. It left behind a hard lesson about what happened when the federal government made capture easier than protection. The law had treated movement like suspicion. It had turned travel, work, and escape into something to be hunted. That legacy persisted in modern arguments over due process. Americans later fought over a basic question. When the government claimed someone broke a law, how much proof had to come first? The Fugitive Slave Act had shown what followed when hearings were thin and power moved fast. Speed became a weapon. And once a system rewarded quick removals, mistakes did not look like accidents. They looked like features. The same tension returned in fights over federal versus state power. People argued about when Washington could override local rules and when states could slow enforcement to protect residents. The old story kept resurfacing because it had set a pattern early. National authority had been used to force cooperation with a morally violent system. The contrast stayed sharp. At the founding, slave catching had been protected in law and the consequences echoed.